Welcome and thank you for joining Seyfarth's webinar, Italian Employment Law Simplified, a half-hour guide to employment and labor law in Italy. All participants are in listen-only mode. You're encouraged to submit questions through the program through the Q&A section located on the right side of your WebEx window. We will do our best to get to everyone's questions. All unanswered questions will be followed up by email after the webinar. For those interested in CLE Credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and it is required for CLE Credit. Copies of the webinar recording and presentation materials will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Dan Waldman. Dan, you may begin.
Thanks, Sophia. Hi there. So thank you so much for joining us today. We're here to talk about fundamentals of Italian employment law. My name is Dan Waldman. I'm a partner in Seyfarth's Global Workplace Advisory Team, where we give advice to clients on their workplace issues wherever in the world they arise. And joining me today from Milan is my partner, Sofia Bargellini. Sofia is an employment lawyer and fluent in Italian and in English, and provides commercially sound and prudent advice to multinationals and Italian companies, both in both an advisory capacity as well as in contentious employment law matters. So with that, why don't we jump right in? Next slide, please.
I think we can go directly, to slide number 6. Sophia, please. Hello, everybody. Thank you for joining us. Today we are going through a very quick and brief description. Yes, next slide. Thank you. The agenda. We are going through a very quick and brief description of how the Italian system works. We're going to speak about 4 main topics. So we'll go through dismissals, RIFs, if it is possible in Italy to make unilateral changes to salaries and duties. Then we'll go through very quickly the collective labor agreements that are a key topic that are a real characteristic of the Italian system, and then we will briefly speak about the role of unions. Obviously I'm here to speak obviously I'm here to speak about whatever, but this is a quick description of my, and this flag is a very beautiful one. So we are here to speak about the system, the Italian system in general. And let's start with this very beautiful first slide. The Italian system rotates around 2 essential points: having an employment contract, having an employment written contract, the applicability of collective labor agreements. Collective labor agreements are signed at the national level and applies, we will see in which way, basically to all employment relationships. What it is also characteristic of my system is the fact that once we hire someone in Italy, we have to declare, to notify the authorities, both the Ministry of Labor and the Social Security Authority. Don't be terrified by this. It's a very simple communication, normally handled by the payroll consultant. We can move to the next slide, please. Dismissals.
All right. Well, the starting point for us talking about dismissals is to sort of push off from the U.S. as our starting point. So in the United States, almost everywhere we have employment at will. And that means, of course, that employees can be dismissed at any time for any reason, with or without cause, notice, or a reason, except for an illegal reason. It's very easy to dismiss employees in the U.S., but this concept of employment at will is what makes the U.S. so fundamentally different than everywhere else in the world, including Italy. And I think starting with dismissals probably makes a lot of sense, but recognizing that the U.S. is sort of the outlier here with employment at will that doesn't exist in Italy is, I think, perhaps our good pushing off point. And so over to you, Sophia.
Thank you. Yes, well, dismissal at will exists just for a very short period of time also in Italy, because we can dismiss people without any reason, so without grounds, during the probationary period. After the probationary period, however, we need reasons to dismiss people. We need reasons, so fair grounds for dismissing people, which means that we must justify the decision to terminate an employee. The reasons for dismiss people are stated basically by the law. They are economic reasons or reorganizational reasons, or we can dismiss for misconduct as well. Economic reasons are the one linked, for example, to a market crisis or a company, I don't know, company crisis in the market because of competitors. So we should have the proof of the economic grounds behind the decision to terminate an employee. The same for a reorganizational reason. So you decide to downsize your workforce because you want to streamline your organization and you just decide to cut a role. Or we can dismiss for misconduct. The dismissal for misconduct is a dismissal strongly linked to the employee's behavior. So there's something that the employee did bad, so did something wrong, and the misconduct is so serious that we can terminate him. Where there's no definition, there's no limits or benchmarks in the law, in the Italian law, that defines what is a fair economic dismissal, a fair economic restructure, a fair reorganizational reason for dismissal, nor a misconduct. But in the national collective labor agreements, we can find the misconducts that may lead to dismissal. Obviously, the lists that we can find in the national collective labor agreements are not exhaustive, so the employer has and will ever have the chance to evaluate what's serious in the company, serious enough to dismiss people. But what it is important in Italy, and we must have a reason to dismiss employees after the probationary period. We can move to the next slides, please. Thank you, because I want to underline how it is important not only having a reason for dismissal, but also following the right procedure. So here I'm just giving you an example of what a procedure may be, so the procedure for dismissing an employee for misconduct, but also the dismissal for economic reason or organizational reason must follow a specific procedure. So just remember that not following the right procedure for dismissing people may lead to have a null and void dismissal, even if you have fair grounds. So it's far more important to follow the right procedure than to have grounds, because if you don't follow the procedure, even if you have grounds for dismissing people, then your dismissal is null and void. So just basically call your lawyer, your Italian lawyer, where you decide to dismiss an employee. Just call your lawyer and follow the right procedure. Here, the example of the dismissal for misconduct. So the dismissal for misconduct can be issued at the end of what we call the disciplinary procedure. So the employer, the disciplinary procedure starts with a letter from the employer setting out the alleged misconduct. So you notify to your employee what went wrong. So what you think he did. Then the employee, this is in writing, then the employee has 5 days to file his justifications, which means that he can file a letter, so he can write a document, or he can even ask to be orally listened. So you organize a meeting and he can show and describe his view of the facts during a meeting. After the employee filed his justification, the employer can issue a sanction. In the disciplinary process in Italy, we have different sanctions: oral warning, written warning, fine, suspension, and the last one is dismissal. So you can't fire an employee for misconduct if you don't follow this procedure, which is the disciplinary procedure. This is only, as I said, this is only an example of one of the procedures we have in the Italian system to dismiss employees. When you decide to dismiss the employee for economic reason, you also have to write a letter to the employee and to dismiss it. So, and there are also other procedures. So, for example, sometimes the Ministry of Labor, the local office of the Ministry of Labor may be involved. So, just remember. The reasons for dismissing employees are really, really important. The procedure is important as well. We can move to the next topic. So we can move to the next topic. So unilateral changes to salaries and roles. I know that from the US perspective, it's quite, an interesting topic. Dan, you want to tell me what the US normally, the US companies normally deal with unilateral changes? Maybe it's really different from what we can do in Italy.
Sure. Yeah, this comes up often. U.S. companies or companies that are based in the U.S. And are global are accustomed, again, coming back to this idea of employment at will. One thing that goes with employment at will is that the employer has the right and the ability to make changes to an employee's terms and conditions of employment, also at any time, with or without notice, cause, or reason. There's some wrinkles to that, but for the most part, that's the case. And in my experience, it's sort of very striking, the difference outside the U.S. for employers to see that making these changes, making changes to, say, a compensation scheme or an annual leave vacation scheme can't frequently be done unilaterally by employers like they can be in the U.S. But I think our audience would be better served by hearing from you about the standards in Italy, Sophia.
Yes, of course. So what we can't do is that we can't, in Italy, we can't remove the employee's rights, so we cannot lower the employee's salary. It's basically not permitted, so we can't do that. We cannot demote people, so we cannot, demotion is not allowed unless we find an agreement to avoid dismissal due to restructuring. So even if we can, in theory, demote people when demotion helps in avoiding dismissal due to restructuring, the reality is that we, in any case, suggest that, because sometimes we need an agreement with the employee. However, the employers can change the employee's roles, provided that you're not demoting them. So provided that you guarantee to them basically an equivalent role, which means equivalent responsibilities and equivalent tasks. So you can change the role, but you must maintain, tasks, and responsibilities. So you are guaranteeing the employee an equivalent role. This is always permitted, and this is something, you know, a little bit strange for the Italian system. So sometimes we think we can't do anything, but in this specific case, the employers have some room to change the organization, even without, you know, necessarily restructuring it or finding agreements with the employees. We can move on to the next topic, which is also next. Thank you, Sophia. Next slide. So I want to spend a few minutes speaking about collective labor agreements. Collective labor agreements are something really characteristic of our system. Collective labor agreements are agreements negotiated at national level by the employees' unions and the employers' association. So the employees unions and the employers' association at national level meet normally every 4 years, and they negotiate these collective labor agreements that rule basically the entire life in the employment relation, so the entire employment relationship, from when it starts to when it ends. It is really characteristic of the Italian system because the discipline, so the rules on the employment relationship are in the law as well as in the collective labor agreement. So in the law, we can find the main rules. In the collective labor agreements, we find the details of what the employment rules are, and the collective labor agreements set the minimum terms and conditions of employment, which means that you can find in the CLA applied to your industry, so in the industry where you're working in, the minimum salary, the minimum days of annual leave that you must guarantee to your employees, specific rules on working time. Working time obviously is ruled by Italian law. Working time is ruled by the European directive, but in each collective labor agreements, you can find the specific discipline for the specific industry. For example, shifts are differently ruled in the mechanical sector and in the logistics sector, or also differently ruled, for example, by the telco CBA. So you can find the specific discipline for your industry. Then the collective labor agreement set the probation length. So the maximum probation period in Italy is 6 months, but obviously you can apply this long probation period only to high-level employees. Low-level employees will have a lower probationary period. The same applies for termination notice. I think now, before moving to the next slide, I want to remember all our attendees the CLE code, which is SS8987. I repeat it again. The CLE number, the CLE code is SS, like Seyfarth show, 8987. We can move on, thank you, to the next topic, which is the role of the unions. What I want to underline is applying or not applying a national collective labor agreements, because you are free not to apply a national collective labor agreements, but the minimum terms and conditions will be those provided by the national collective labor agreements. But applying or not applying a national collective labor agreements does not mean that your company will be unionized. So I want to underline that even if you decide to open an office in Italy and you decide to apply a national collective labor agreement, this does not mean that you are automatically unionized. So employees will always have the freedom to decide whether they want to join a union association or not. If they decide they want to join a union association, they will be entitled to union rights even if you don't apply a national collective labor agreement. This is why I normally suggest a new company deciding to open an office in Italy to apply a national collective labor agreement, because this does not mean you will be automatically unionized. Applying a national collective labor agreement gives the company, from a payroll perspective and also rules perspective, much more certainty. The roles of unions are set by the law, and the unions have the rights to promote their activity within the plant, to organize meetings, to speak to your people, to your employees, and they have all this bunch of rights guaranteed by the law, and the employer can never deny those rights. This because there's a urgent procedure that the unions can file in court, which is called anti-union behavior procedure, with which unions protect their rights, and the judges tend to quickly protect unions' rights, because denying union rights is strongly forbidden in Italy, and there's an automatic remedy, like this one I just mentioned. So the anti-union behavior, claim that is often used by unions when they see their rights denied. What I want to underline is that you shouldn't be terrified by unions in Italy, because unions in Italy are part of the system, and as everything that is part of the Italian system, also unions can be part of the working system, and can be a support for the employers. So it's quite strange to say something like this, but I want to share with you a few thoughts that I had in the last 2 years of crisis with COVID, and basically in Italy also we shut down also the productive activities for a couple of months. Unions were a support for employers. Few examples. The Italian state gave to employers a lot of support through temporary layoff funds. Those support could be, the employers could apply for those supports only with the unions agreement. Obviously, the unions were more than happy to help the employers and to find a solution for the temporary crisis we faced. But in my experience, I saw a lot of unions negotiating a salary reduction on behalf of the employees. This was like super strange. And at the beginning, I was afraid, because I said, okay, good, they are negotiating something they couldn't, because only the employee can negotiate a salary reduction. It's forbidden. So it's also difficult to negotiate a salary reduction, even if the employee wants to do that. And the employees were not involved, and unions negotiated with the employers salary reductions to face the crisis. And the employees never claimed against those salary reductions. This means something. And I think in my experience, I saw unions were the best friend of the employers during the COVID crisis. And obviously now they're back to their role. So they are asking for restoring the salaries, and to, restore all the rights that they dismissed for a while. But in certain cases, they can be a help and help for the employers. I just to let you know that that's not there's a different side of unions relationship. We can now go, please, to the very last slide. So when we must involve unions, there are 3 cases in which we are obliged as employers to involve unions. So in case of mass dismissal, so to start the mass dismissal procedure, we must involve unions, speak to them, negotiate, and it's strongly suggested to find an agreement with them if it is possible. We then have to involve unions when we start a TUPE transfer process. So in case of transfer of undertakings, when the employees are moved from a first employer to the second employer, the unions must be involved. And then there are NCLA requirements. So there are, and it is also stated. Oh, sorry, please.
No, and NCLA, we're talking about national collective labor agreements, yeah?
Yeah, sorry.
No,
It's
okay.
national collective labor agreements. The national collective labor agreements required, which is also stated by the law, that when the employer takes a decision that has a very big impact on the employee's life, even if it's not mass dismissal, it's not TUPE transfer, you have to speak to the unions. I can make an example. If you decide to change the working time organization, bearing in mind that you have to respect what the European directive and the Italian law on working time state, you can, for example, provide for different shifts. If the shifts this change lead to a very big change in the employee's life, this is an example of a big issue that may impact on the employee's life and on the employee's working relationship. And this is something that should be communicated to unions. Obviously, employers in Italy not always comply with this last obligation, and sometimes it ends up unions end up in court with anti-union behavior claims because employers implemented big decisions without speaking to the unions first. I just finished my presentation. So I don't know if we have questions from.
We do, and we have luckily just a couple minutes, but I think we have a number of questions, and one of them I think that's really interesting is do the national collective labor agreements typically apply to senior managerial level employees as well in Italy?
Yes, because we have national collective labor agreements for normal, what we call normal employees, so blue collar, white collars, and medium level managers. And then we have different and separated national collective labor agreements for managers, what we in Italy call dirigenti, so for dirigenti level employees.
Oh, wow, that's great. And if we have time for one other question here, so is it possible for an employer who has not accepted a national collective labor agreement in the workplace to still have a union locally?
Yes, it is possible. In my experience, I saw companies negotiating and signing their company's collective agreement with the unions, so avoiding applying the national level one and applying only the company's collective labor agreement. This is something which may be really hard to obtain in the big sectors. It is something that I saw happening in the airline sector, where there are few players, and many of those players have their own companies' collective labor agreement, and they are refusing to apply the national collective one. So yes, it is possible. Obviously, it depends also on the industry characteristic.
All right, well, thank you. I think even though we have so many questions, I think we are out of time. So with that, please accept our thanks for joining us today. And should you have any questions, of course, please don't hesitate to reach out to Sophia or to me or to any member of the Seyfarth Global Workplace team. Thank you very much for your time today.
Thank you. Bye-bye.